I did an extra 30 days, the extra 30 days.
Well, if you keep this up,
That's my attorney.
you're gonna be here another 30 days. Do you want me to adjourn this case again?
No, I don't want to talk. I'm really actually having dismissed.
No.
The simple fact that
We're not doing that. 5-00791 FY State of Michigan versus Timothy Dansby.
Yeah, people.
7446, standing in for the attorney of record, Van Gonick, and appearing on behalf of Mr. Timothy Dansby, who stands to my right. Mr. Dansby, can you please state your full name for the record?
Timothy Dansby.
All right, Mr. Dansby, we're back. Do you mind having Ms. Miller stand in for Mr. Gonick for today's hearing?
That's up to the court. You know, I still reserve my right. I mentioned all of the previous hearings, but part of today's process has been going what it's going to continue doing what it's doing. But I still
Does that mean you don't mind her standing in?
want to interpret.
Okay, you know what? I'm not gonna play that game. That's a yes or no question.
I don't even.
Okay, do you want to adjourn it and see who it is? You have a right to have the counsel of record present if you want to be here instead of Miss Miller. And this is basically for a probable cause conference and adjourn date on a retail fraud first degree. When we had adjourned it before for your lawyers to get video discovery. So do you mind her standing in or no? Okay, so you don't want a lawyer, sir? I'll release him if you don't want one. Nobody's gonna force you to have a lawyer to help you. If you want to do it all yourself, do it. Do you want me to release the lawyers?
You know, same firm soon right now.
Do you want a lawyer? Yes or no? It's a real easy question, sir. It don't take all day. Listen here. Okay, if you don't answer the question, I'm gonna release the lawyers. If that's what, because you've been complaining the whole time about, I didn't ask for no state attorney. I don't want to, I don't know what it, whatever you gonna do. No, I'm not doing anything. I didn't appoint the person in the first place. I didn't do it. Okay. So you don't want them? Is that what you're telling me? Do you want them? Yes or no?
I'm on the same.
Sir. Listen, this is not going to be a matter of semantics. Do you want one or not? Because nobody's going to force a lawyer on you. I'll be happy to handle this case with you by yourself, doing whatever you can do to help yourself. If that's what you want.
I still ain't got my discovery,
So, do you want a lawyer?
I'm sorry, I'm still on the same thing.
I don't even know what that is. Whatever your claim is, I don't know. Okay, let's release the lawyers. All right. Now, you're not getting another one. I'm just telling you.
I reserve the right for judiciary and judiciary finding on the legitimacy of the court.
You're not getting another lawyer, okay?
Oh, yeah, I said
I don't know what you can reserve what you want. I don't mind.
finding the other court and the legitimacy of the court as far as the
Sir, whatever you want to do, you can do. But since you don't want a lawyer, I can't by law give you one. So
that was three adjournments ago.
guess what? So
Lord have you given me the things that I need.
okay, sir, nobody can give you anything but a piece of paper. They can give you that. They could give you the police report. They cannot give you the videos because there's no way for you to watch them.
Make sure that the law library at the court, it will order that the law library at the court either have a clerk or somebody to present the information for me to see the video. I don't know. Maybe you just don't want to get done.
Sir, I don't even know. I don't know anything about your law library wherever. All I know is these video files, they're files. They come on a computer.
So the law library should somebody should be giving people at the law library a heads up to make it law.
Well, you know what? That's up to you to figure out how you're going to get them.
I'll let the second circuit figure it out. Let the second circuit figure it. You know, probably just second court, Supreme Court, we let them figure it out. I'm straight. Well, I ain't doing nothing.
Ready for me to take them?
You know?
Your Honor, would you like, Mr. Donovan to file any sort of motion or
No,
hold order to have him withdraw?
no, I'm going to write an order out right now, releasing him.
Your Honor.
And so we will reset this, I guess. I don't know why we got him. We could actually bring him back out and he could decide what he wants to do today.
I do know that, he is wanting to have his preliminary examination. That is.
Okay, well, let's set it for an exam then. How many witnesses, Mrs. Shockley?
Probably just gonna be one.
All right. You want to wait for your order? You can.
Okay, thank you. One witness.
Right.
Yeah, one witness and one defendant that's gonna make it way longer than it's supposed to be. So factor that in.
Court's available October 3rd at 10:30.
All right. So October 3rd at 10:30. Is the exam date. And could you ask Mr. Gonick to make sure he gets a discovery, what he has, over to this person?
I believe that paper discovery has already been given to him. I'll see if the court or if the jail will allow us to give any sort of thumb drive or anything like that that encloses the videos.
This record, I would advise the court, the discovery, the AV discovery in this matter is 99% police body worn camera, which has the defendant in it, and there's only one in-store video of the defendant walking past that. So. You
Okay.
didn't know it.
Okay. Well, good. Just make sure he sees it.
That's
Just
what I'm
some of your best efforts on that. And people of the state of Michigan versus Timothy Dansby. Sir, what's your name? All right, Mr. Dansby, good afternoon. Mr. Shockley, place your appearance on.
Track on behalf of the people.
All right, today is the date.
The defendant rejected appointed counsel, but under U.S. law, waiving your right to an attorney means you're responsible for your own defense. Smart strategy or costly mistake. Viewers may already see where this is headed.
Scheduled for a preliminary examination. This is on one kind of retail fraud, first degree. People prepared to proceed.
Just,
All right, any preliminary matters?
did you, pursuant to the court rule, confirm that the defendant still wishes to represent himself as this is a critical proceeding?
No, but do you still wish to assume he did?
Yeah, they just have.
He's been-
Voluntary.
He's just been asking all this time, would you still want to represent yourself? You've been telling us all this time, do you want to represent yourself?
I've been wanting to represent myself.
Okay, so you want to proceed today by yourself without a lawyer, right?
Not before I let it be known that I still never received my full discovery.
Well, what haven't you received, sir?
I haven't had a chance to go over the videotape because one of the witnesses in the videotape that I know that when I was speaking to him and was saying, letting him know that, look, man, put this stuff back on here because I'm choosing not to buy it here and I'm going someplace else. So it wasn't like I was trying to steal nothing when I told the guy that particularly I wanted to make sure that he's be available to be questioned.
I don't know who he's gonna call. See, this isn't a trial. So this is just your probable cause hearing. So the prosecutor has a very low threshold burden of proof. He doesn't have to put on every witness, he said. He doesn't necessarily have to use the video. He might. And if you say the video means something else, that creates a question of fact that would go to trial for the trier fact to resolve. And of course, you get an opportunity to question about the video in depth at trial.
Also, I like to mention the fact that, you know what I'm saying, that it's been a delay because I don't know who these people have been coming up here. I've been telling the court that I've been wanting to represent myself.
Well, you've been representing yourself since the last time.
Well, I've done with them saying at the county jail, they said without the court allowing them to know that I was representing myself, there was certain information I couldn't get. They would not give me. Like the Michigan court rules of evidence. You know what I'm saying? For as far
I've never heard of the court having to tell the jail you're representing yourself. I've never heard of that.
The new technology, they used to have a law library you could go. But now you can do everything over the computer.
Okay.
You got to leave a request. In order for them to fulfill your request, they have certain criteria that you got to show ahead of time.
Well, sir, I don't know anything about what the jail's criteria is.
And also, you know, I asked, you know, for a standby lawyer.
But they don't do that.
But from my understanding from previous experience, you know.
What
From
what year was that?
Federal circuit court and from other court.
Federal Circuit Court.
No, I know, and circuit court, they have done.
This is the state system.
There has been opportunity to have standby lawyer for instances where they could confer certain information that the prosecutor might not want to give to me because he might feel he's better than me or something. Because he feels that my counsel doesn't like.
Listen, Mr. Dansby. We can't
He
keep,
might allow me to receive.
no, of course you got, that's not true. You have a right to represent yourself and you do have a right to get discovery. But what you can't do is come in here on the day of the hearing claiming that, oh, now you want to stand by counsel.
I said,
Okay, but I'm telling you,
I'm just saying, well, from my
Well.
experience, it's always been, standby counsel been set.
I don't know what your experience is. I just know what Michigan and I don't know when you got,
Well, of information.
okay, sir.
And
The Michigan Indigent Defense Rules, they have a whole new program that's been started a few years ago. So we used to do standby counsel and anything like that. We used to do that all the time when the court was appointing. Now they have a whole system. They don't pay for that. They say if the defendant wants a lawyer, fine, but there's no quote standby lawyer in their view, so they don't pay for that. I didn't make that rule. The person,
I couldn't verify it if I wanted to without.
well, the person that,
Without the people in the jail who's running the law library information, able to send me the information that I need, because without them having, and for their quote.
okay, what information
Their
do,
quote unquote.
sir, what information do you think you need just for a preliminary exam?
Your Honor, just-
No, I said for Michigan Indigent Defense appointment.
So then, you said it used to give standby counsel.
I said we did before that system was created.
I'll be chance to update on the system, you know?
Okay, but that has nothing to do with this.
Court rules of evidence.
Your Honor, I'm gonna, just so I can expedite this, and to satisfy the defendant, at the circuit court level, the circuit court has the budget and the ability and the staff to appoint a standby counsel once he gets up there. And once we finish this hearing, he may be up there and he can make that request then, and I'm sure the circuit court will have no problem immediately assigning him an attorney to advise him as he represents himself. As far as the people are concerned, the court has been complied with. He's freely and voluntarily relinquished his right to an attorney. May I call my first
So the
witness?
court, yeah, I like to also state that I still haven't received my discovery, and my date was postponed because of some guy who said he was my attorney. I did an extra 30 days,
Well, if you keep this up,
that's my attorney.
you
Why
gonna,
wasn't my?
you're gonna be here another 30 days. Do you want me to adjourn this case again?
No, I don't want to talk. I'm really actually having dismissed.
No,
For the simple fact that.
we're not doing that.
Or ask for a personal bond, because I've been had my cases adjourned on other people's. Had nothing.
Sir, you the one that asked for new lawyers or
I
no,
asked for
or no lawyer.
ask for any new lawyer because I never accepted the first. I have never signed for an appointment of an attorney from the very beginning, even at.
Okay, sir. Well, we're gonna proceed with your preliminary examination without a lawyer. So you should be happy today that you don't have one. And then when you get to the circuit court Ask them to give you a lawyer. He just said they have a budget for that.
Ask them to give me my discovery.
What discovery don't you have? What tape?
Yeah, I'm gonna play the tape for him, today anyways. There's no right to it. There's not even a right to discovery before a preliminary exam, technically underneath the court rule. I mean, we deal with this all the time. So this is just an intermediate proceeding. It's not gonna affect anything. As you know, attorneys don't even ask questions a lot of the times during preliminary exams because it creates a question effect.
But they certainly don't call. They might ask questions, but they don't call witnesses.
Not in all situations. With all the preliminary exams. But there's-
Okay. Have a seat, sir, unless you want to stand up for the whole hearing. Call your first witness.
People go to the same Robert Stanley.
Okay, Mr. Shockley, are you ready?
I am ready.
Okay. Raise your right hand. Do solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth.
Yes, sir.
All right, thank you. Have a seat. And Mr. Shockley, whenever you're ready.
Yeah, sir, when you are ready, will you please state and spell your name for the record? Who is your employer?
Meyer,
What is your job title with Meyer?
Asset Protection Team Lead.
Asset Protection Team Lead?
Yes, sir.
And how long have you been employed in that capacity by Meyer?
Since January of 2025.
Did you receive any specialized training to have that title or that role?
Yes.
And what do you do? What kind of training?
So it's a multitude. So over years, Wicklander certified, and then different courses in asset protection and policy related.
Were you employed in that capacity on July 26, 2025, around 5:30 p.m.?
Yes, sir. Okay.
And so do you work at a specific Meyer store or multiple stores?
I'm assigned to the one in Southfield.
Is that located at 28800 Telegraph Road,
Yes.
City of Southfield,
Yes.
County of Oakland?
Yes.
On that date, around that time, did you identify a,
The defendant rejected appointed counsel, but under U.S. law, waiving your right to an attorney means you're responsible for your own defense. Smart strategy or costly mistake. Viewers may already see where this is headed.